All right, so welcome. It is, July 22nd. We're coming to the end of summer. We're really, I call it the end of the hot summer selling season, although it may not feel like it. Um, Coming to you today from that wonderful town of Ann Arbor. So, I'm going to be talking with these guys, looking at them also, and hearing from them. Um, but today, it's a great time because, really we've had now almost 8 full months, 7 full months of doing real estate in 2025. Hopefully you're getting a load of experience. And typically if we get a load of experience, we also get a load of problems. So here, before we got started, you guys, we were just talking about what we do in real estate is we fix everybody else's problems. If it were easy to sell real estate, we wouldn't even have a job. So it's about handling the problems. And because that is what we do, we have to make sure that we're always looking and practicing risk reduction. I have never been in court, right? Yeah. I've never had a grievance filed against me. I chair grievances and code of ethics, arbitration, and I'll tell you, it's interesting to go through and hear what you hear in those. So what I'm going to bring to you today, a bit of that comes from my experiences through the years with that, my 38 years in the real estate business, in all the learning and education that I've got. So we're going to share, but I'm also going to say thank you to Jason Sakis. Jason is a broker and an attorney. I don't know if that's good or not, right? But what I know is that it's good because I borrowed some of his material, a lot of his material, because he's brought it with both of those things together. And even talking with him yesterday, managers, he talked about doing a review. And matter of fact, agents, think of this. It takes him an hour to review a file for closing. It never quite took me that long, still doesn't. But he's doing it from a legal perspective. So there's so much more that we could always look at. Bottom line, it really brought up the aspect of how important risk reduction is, because when we got that license, liability jumped right onto our forehead. It's like, go ahead, sue me. I'm a real estate agent. With that, we have to be careful and then take a look at what is it that we can do to keep ourselves out of the court, to keep our company out, to protect our clients. And really, for that matter, why have the other clients have to sue someone? Or even our clients to have to sue them. If we do our jobs right, we can protect everybody involved in a real estate transaction. So hopefully you got pen, paper handy, and here we go. So I want to talk briefly about errors and omissions insurance. We have that, but how many of you know what it takes to be able to kick that in? How much does it cost you if you actually have somebody file a lawsuit against you? So a key is that I'm going to share with you the general that I know. So don't take this verbatim, but typically we share in the first part of it. Before your errors and omissions even kicks in, you're going to have a $10,000 payment, of which is shared between the company and us. Now, I don't know about you, but I really don't want to give up $5,000. And the last time I was involved with it was as a manager, and to me it was totally frivolous against one of our agents. It took all the way to get in front of a judge for a former client to say, yeah, it really wasn't that way. That's the short story. Cost her $5,000 to get her to admit that, and $5,000 to defend from the company to defend, to get her to say that. $5,000 each when we were innocent. So risk reduction is really important because it's going to be out there. You're going to run into things to where people are going to question whether or not they were taken advantage of, whether or not there was an error, whether or not there was an omission, whether or not you did something that you shouldn't have done didn't do something you should have done. So the E&O, I just want you to know that. But if you have anything that you believe could rise to the point of a lawsuit, even the threatening demand letter that normally goes out from an attorney, you need to get to the branch manager right away and apprise them of what's going on. All right? All of that is just so that we can take the appropriate measures, start lining things up, and get them involved to hopefully prevent even a demand letter. So, all right, let's do this first. I got to, the more I'm out here talking with you guys, the more I'm understanding we still don't understand agency. Okay? I'm only going to touch on it because we need to know this, and that is our fiduciary responsibilities. So a fiduciary relationship can be established when you sign a contract and agreement. It can be implied or written. Yeah. Thank you, Tony. I appreciate that look. Tony just gave me one of these. He looks a lot better doing it than me. Through our actions, because everybody understands, you write and sign a contract, hello, we have fiduciary responsibilities. So the aspect of implying, and if you go back through your pre-license training, Howard, how long has it been for you? 24 years ago, it was still implied agency. What is to imply? If you imply that you are an agent, let me rephrase that. If you walk like a duck, talk like a duck, you might be a duck. In real estate, if you talk like an agent, walk like an agent, you are an agent. You've implied agency. Let me tell you, probably every time where you do this, and it would only be, you only wouldn't be doing it if you reversed it. Agency disclosure. Is it a contract? But if you state that you represent me, are you now my agent? Just by disclosing, just by doing what we are legally responsible to do prior to the exchange of any confidential information with all parties to a real estate transaction, we are to disclose. And if that's the first thing that we do, we have implied agency because we said, I'm going to represent you. Let me throw one out because I really think that we need to be aware of this and people haven't thought about it. How many of us have gone out on a listing appointment? It's a competitive situation, so they're interviewing you and two others. You've been in that situation, you were not the one they selected. Did you ever imply agency? No. I got, thank you, Sonia, somebody that's actually bold enough to say. The others are going, well, guys, when you went out there, what was your intent? When you interviewed for that job, to get the listing, did you ask a whole lot of questions? Did you go that, so what I'm going to do for you is, that sounds like me, you implied agency. Because here's what we do. We never disclose, verbally or written, most of us, none of us written, until we get the contract signed. That's when we pull it out. So up until that point, guys, you implied agency. Now, here's where I want you to understand. Why is that, and could that be troublesome? Yeah. Howard goes out, interviews, doesn't get the job. Now, I know Howard works with a lot of buyers. Howard gets a buyer, signs them up, and he goes, oh my God, I was just thinking, I know the perfect house for you. And it's the one that he didn't get. Now, if he implied agency and he's now representing a buyer, what might he have created? Say it out loud so he can hear you. Everybody out there, say it again. Jason, I can see you lipping it. Dual agency. You ever got in trouble for not disclosing? Because it's happened. If you've been in the business for any long, it's happened. I just want to point it out. You should at least disclose to the buyer that you interviewed for this job. You may have confidential information I can't disclose to you. Because you got that because you implied that you would be representing them. Okay? Now that's just a tidbit. Want to protect yourself? Really, what should you do? If that was Howard, what should Howard do with that buyer? What should he do with that seller? In reality, we'd redisclose as a dual agent. That would be risk reduction. So this, I'm just going to cause a whole lot of thinking today, guys. I'm not going to go, this is what you will need to do. Now, I will tell you if you need to. But just know, we've been in that since 1995 when agency became prominent in representing buyers on top of sellers. Okay? Okay. I got a question here, guys.
My buyer that, I did an interview as a listing agent for this. The only thing that I really can't disclose to them is anything of their personal nature, but anything in regards to the house and conditions, I'm obligated to disclose.
Yes. So Elizabeth just brought out the aspect of this scenario. Howard would not be able to disclose any confidential information, right?
Of the seller.
Of the seller, nor could he do anything with the buyer to the seller. So we have to keep that in mind. So that would be, I asked a really simple question. What's got you moving? That could harm the seller's negotiating position. When do you need to be there? That could harm the seller's negotiating position. It's things of that nature that we have to do because they, again, dual agency, we cannot disclose. Duties of confidentiality are 100%. That's an easy thing to be able to remember for that. So let me move to the next bullet. Our broker is the fiduciary. Now I'm going to say, who is the broker? Well, I just heard Chris Hendricks. Well, if you're on the blue side, who is it? It's not who, it's what? And it's Coldwell Banker. Coldwell Banker Professionals. On the gold side, it's Coldwell Banker Professionals. It's that non-living entity who is the broker. But as Chris always puts it, who's going to be able to wear the orange jumpsuit if anybody gets in trouble, right? So that would be Chris at the top, who would be able to enjoy wearing that orange jumpsuit. So when we talk about protecting the company, protecting the broker, that's really what we're talking about. Come on. I got two computers here, guys, so I can kind of keep on what you may be throwing out to me here, but I'm not seeing anything.
People that could potentially get thrown in prison.
Yeah, 800 people that we got the potential that could put Chris in an orange jumpsuit. That's why we're talking about this today. He doesn't want to end up there. Yeah. All right. Breach of fiduciary duties is done by a client. A client would have to prove that you have a breach in your fiduciary duties by, one, there has to be an existence of that fiduciary duty. How's that easiest and most common? Written contract, right? There has to be a breach of those duties. And of course, there has to be damages caused. If there are no damages, then they really can't do anything. Here's the most interesting part, because, I've had a number of discussions with the summer, people taking breaks. I'm going to have somebody hold an open house. I'm going on vacation. And then there's a settlement. And of course, here's what we know. There's agency law and fiduciary duties. And that what we should be doing is appointing as a designated agent anybody who steps in for us, either as a open house agent or as me taking a break for a week, and I'm going to have Sonia take care of things for me. She's going out showing buyers a home. What does she have to have before she can show a home? Contract. But a contract already exists. So really the only thing we've got to do is designate that she would be taking care of these buyers. Contract already exists for the broker. So if Matt had the buyer and Matt's taking a break and he says, Sonia, can you take care of this for you or for me? We should, in risk reduction, have a change in agency relationship designating Sonia to also represent. Guys, that's risk reduction. Okay? But here's the biggest thing. I get people who give me a kickback on this. And listen, I know this stuff is a pain in the butt, but it is only a signature. Okay? I hesitate because, like, how do I say this and not anybody hate me? So I just got to say it. You don't even know what your fiduciary duties are. Now, if you do, thumbs up. You've been with me for a few times and you see what I've got here for old car, and you probably know what that means. Jason, I bet you could actually tell me what the old car is, couldn't you? Let's see. Go for it. O is?
Obedient,
You got
Obedience.
me.
Yeah. Obedience. What's the L? You guys can play too. Otherwise, you're proving my point. Loyalty. Elizabeth has got loyalty. D is
Disclosure.
disclosure. C is the opposite.
here, no, shit.
Can't tell them. I got to hold it.
Confidential.
Confidentiality.
Confidential there.
A is the accounting. It's really more about the take care of the money, but I also like it as accountability, but reasonable care. Reasonable care is due diligence. So if you wanted, you could even put it as old car or old card. So when you see this, it's an acronym for you remember what your fiduciary responsibilities are. But here's my question to you. Why are we all worried? Why would we worry about designating somebody else to represent somebody holding my open house when I don't even know what my fiduciary duties are? Okay? It's a simple thing. So keep it simple, but again, it's risk reduction. Should we, if we want to reduce our risk, have anybody come back on us? Yes, because that would be proper to do. Okay? Any
Darwin?
questions about that so far, guys?
Dimitri
Let me
has a
just check here in my
question.
chat. Martha, was there something there?
Yes. My email has verbiage at the bottom that no agency exists until and unless a written form is executed. How would this play out in a situation where a property I didn't get to list if I exchanged emails with the property owners before the listing interview?
Dimitri, is that on ours? I mean, it may be on there, to tell you the truth. Look, if anybody ever comes to us as a manager, one of the first things that we're going to say as a manager is, bring me the paperwork. I need to look down to an individual word because an individual word could change everything. What I would
believe
tell
that-
you, Go
I
ahead,
believe
Martha.
that it is a statement above his email signature.
Oh, I got you. I like that you have that on there. Matter of fact, we will probably address something similar to that. If I didn't drop it off, I might have dropped it off. It's there's an old Latin term. Has anybody ever heard the Latin term of anus protectus? Okay, good. I'm checking for smiles. All right, Harry's got it for me. Don, thanks. I need that. I learned that from Floyd Wickman. If you've been in the business for a while, Floyd Wickman, he's my man. I would consider him one of my mentors, but that was something that Floyd threw out and it landed with me. Everything that we do, we have to do to protect ourselves, our company, our clients, everybody that we come in contact with. So I think it's a great thing to have out there. But what I would give you, Dimitri, is this. Walk like an agent, talk like an agent. You're an agent. So you can say you're not, but all I got to do is prove that you told me. And here's how simple it could be. Well, gee, that's a great question, Tony. Let me see what I can do for you on that. That statement by itself could be taken, construed as an implied, I'm representing you. That statement by itself. So even though you put in writing, I'm not, you just said you are. Let me take it a step farther, matter of fact, Dimitri, because wow, it's great when I think out loud like this. Let's take the agency disclosure. Let's create a scenario. This is coming off the top of my head because it happens. Has anybody had a buyer whom they represent and they go find them a for sale by owner? Whom do we represent? The buyer. Do I have to disclose to the seller? I love it when I see the faces like this. Let me check out there in Zoom world. I have to disclose to the seller. What am I going to check on the agency disclosure for the seller? What am I? I hear buyer's agent, buyer's agent. You good, Tony, with that? All right. Branch managers, I think I'm discovering by looking out here on the faces and what I'm hearing here, we got to do agency again. Because you should know automatically. And it's the reason I asked the way I did. Whom do you represent? The buyer. What do I disclose to the seller? I represent the buyer. I am, check, buyer's agent. What's the only way that I can be a dual agent? Me personally as an agent, what is the only way with our company being designated agent that I could be a designated dual agent? I have to represent both parties to that transaction. I was just about to go there. You brought it for me. The only way that you can have dual agent as a designated agent is if you represent both parties to the same transaction, either written or implied. So we're staying with Dimitri's question here. I signed that, I represent the buyer. Now I'm negotiating this deal. I go, you know what, seller? You just give me $2,000. I could probably get this thing accepted for you. Now you think, no, nobody would do that. People do that stuff. Now you might not, God bless you. That's probably why you're with our company. But if somebody did that, did they not just imply agency? Do they now represent? And it's the worst kind, it's undisclosed. Undisclosed dual agency. So guys, as a company, we're always more than open and willing to let you do and have you do personally dual agency. But we have to do it the right way. We've got to do everything above board. We've got to sign all the proper documents. So hopefully that answered it, because even though we put it in writing that we were representing the buyer, through our implications, through our actions, through our words, we just started representing that seller. We've created dual agency. And that's clearly in writing. I represent the buyer, not you. And yes, there are lawsuits that come up because of improper disclosure. Good. Okay. And Martha, thank you for jumping in on that. I think we answered them all right. You're awesome. I should hire you as my assistant on these for 30 to 60 minutes every Tuesday. All right, here we go. Let's
Just
see if I still
implied.
got this. Yeah, there you go. All right. So what we really need to do is focus on reducing our risk. And everything that we do, focus on reducing the risk. How do we do that? Here's some basic recommendations. And this is probably the biggest one. Read all of the documents to any agreement and understand every term. Here's what I know, guys. I can look here, I can look here. We don't even know what our purchase agreement says. Okay? I can tell you, you don't know what the agency disclosure says. Now, when I say you, that's a general term, and that means the best percentage of it. You don't know what it says. Because if I ask you what a transaction coordinator is, we got how many people sitting here with us? I probably get many of the same, but most of it is misunderstanding as to what a transaction coordinator is. So I will challenge you today, pull out an agency disclosure and read what it says. verbatim and break it down to the individual parts. Yeah, by the way, a transaction coordinator is a licensed agent who represents neither party and therefore owes no fiduciary responsibilities to either party, yet is performing the services necessary to close a real estate transaction. Now, that sounds like a real estate agent through and through, except for one thing: no fiduciary responsibilities. So if you've ever wondered why is it that we're now saying, well, look, offer a transaction coordinator the same as we would a buyer's agent. They're doing all of the same work. Now, your seller's got to be willing to do that, but why would a seller be willing to do that or not do it? Because you either informed them correctly or you informed them incorrectly. But we need to understand that that's what that is. Well, then it's, what's the purchase agreement say? What are the details to the purchase agreement? As a matter of fact, here's another one. I'll throw it to you very quickly. There's been a little bit of concern with our buyer agency contract that we need one for the tenant. And if you're going, yeah, that'd be a great idea. It's already taken care of on the buyer representation contract. I believe it's paragraph 6. In the event that this is a lease, tenant or a buyer shall be termed tenant. Landlord would be seller. And it takes all of the terms, translates. It's already in your buyer representation contract. Okay? Just want you to know that, but that again just shows you how much we don't really know our contracts in detail. Okay? AVO, avoid verbal orders. Now we all go in real estate to be binding. What does it have to be? In writing. It's got to be in writing. So avoid verbal orders, because could somebody sue you because you said that? Yeah. Now, is it likely to be binding? Not likely. But what do you have to do? Pay money to defend yourself. Avoid it. So document everything in an email. I may have a conversation with Matt as we're negotiating a deal. I'll then follow up with, Matt, here's what we just talked about. If I'm negotiating verbally with Matt, I'll send an email that says, Matt, here's everything that we just talked about. However, get this to me as soon as possible, because until it's accepted in writing, this cannot be binding. Risk reduction. You've got an offer. This is just one that's because it's like timing. You ever heard time is of the essence? You can't wait. You wait, you're waiting for a problem to occur. Get them everything signed as soon as possible. This is a simple one. How often, branch managers, do we see documents coming through without anything in blanks? We leave them blank. Always, always, always put something in the blank. Okay? Review every document with a perspective of avoiding getting sued at any point. At a later point, you want to review everything from that perspective. You got to think, oh, I don't want to read all the way through this thing. Well, do you want to get sued later? One word can change everything. Taxes shall be prorated as if paid in. Woo! Want to get in trouble and pay a whole lot of money out of your pocket? Don't look at that one. That'll get you in trouble. Because here's the thing, you go toward Lansing. In arrears is how most of those are going to be treated. But what do our Lansing agents have to remember if they come toward us on the east side? We are advanced. Guys, there's a huge swing. It's not just a $5,000 tax bill, because it just went from you're getting credit on it to you're paying it. So we really need to do and hit everything. So, and this is the primary part where I borrowed from Jason, and it's just the common issues that we're going to go through. So First thing that he gave us was to avoid certain issues. Seller's disclosure statements being completed by the agent. Now, everybody, yeah, everybody's pretty much doing this. Don't even assist them. Don't put your pen to it with them verbally telling you. Don't do it. You're accepting the liability. Because, Sonia, you put it in wrong. I didn't tell you to check that. Right? You're liable. Because it's their word against yours. Oh, by the way, you're real estate agents. You're guilty until proven innocent. And ignorance is, I still remember way back when I was doing Con Ed in the 90s. Court cases all the time. You can't claim ignorance. You can't claim that, well, no, they told, no. You got to be able to prove yourself innocent. Just count on that as a real estate agent. Here's another one. Terms of the PA not being understood. Who needs to understand it to help the seller or the buyer understand it? Sections in the PA not completed. We left something open. We didn't address something because we left something blank. But a key easy thing is just we didn't complete it all the way. How many of you are appraisers, engineers, attorneys, electricians, contractors, anybody out? And some of you might be like if I held a builder's license. I don't necessarily want anybody to know that, but if I did, I'm going to say, but you cannot rely upon me for any information. I can't give you that. Because you're going to cause yourself trouble. So always be careful in regards to advising on things that you're not an expert on. They go, ooh, there's a crack in the wall. Well, listen, I'm not an expert on this, but the things I have learned is that if it's this, it's that, but you need to depend upon a licensed inspector, if not a foundation person, which is nuts that you have to do that. But if we're going to cover ourselves, risk reduction, we're going to give that disclosure. It's not us. I'm not a CPA, because when it comes to taxes, here's a common one. Nah, it's going to come up. I'll leave that for right now. Inspection contingencies mishandled. We've been fortunate because I think as a company, we really do a great job of training and education. We've got some great individuals as branch managers who look over and make sure that we got everything taken care of. But please don't write your own clauses. If an addendum does not exist, turn to the clauses. It's in every MLS. It's in SkySlope. The clauses are there. If you've got something that does not exist, see your branch manager. Don't write up your own clauses. And I will, the one that concerns me the most right now, escalation clauses. Want to get in trouble? Or your seller or your buyer? Go ahead and write up your own escalation clause. I will guarantee you, you will be missing something. I can't write what I've put together to help cover the company by going out and looking at all of the circumstances, looking at what attorneys have suggested to come up with the escalation clauses, 2 of them, one with an appraisal guarantee and one without an appraisal guarantee. You're missing something if you don't use those. You're asking for trouble. Inspection contingencies mishandled. As simple as it is, we need to address it so that we do this. What if? So here's a common one. Repairs. Seller to repair leaking roof. What does that mean? Seller to remove and remediate discoloration, mold in the attic. Let's interpret that one. Matter of fact, Could anybody do it then if it's written that way? Could they use anything to clean it? What does remediate mean? Is that what you think? I think it means that I could just go buy a bottle of bleach and I don't do anything else. And now we still have the same problem that caused it in the first place. See, we cleaned it, but we left all the mold spores in there because all we did was disturb it and make it look clean. We didn't take care of the real remediation, which is what caused it in the first place. Risk reduction. By the way, do I really want a seller taking care of what the buyer really wants? I don't want to do it that way. If I can go away from it, because now I could create another problem, because even if I say buyer to approve of, and I could go to the greatest detail as to who can and who should and how much, but does it meet the standard of what the buyer was looking for? Did the seller interpret what my buyer was meaning by it? So if I can ever get a deal negotiated where the buyer just takes care of it themselves, that's the best way. But not always is it going to happen that way. We got to make sure that we take a look at everything. Discussions that you have with a buyer or seller, your client over a phone, and you don't document it. Because see, what's one of the first things that as branch manager, if you come to us, what are we going to ask? Give me a timeline. Well, I told them, do you have this documented somewhere? So now you better have text messages, but I'll tell you, text messages can be edited. It was interesting for me to be able to hear this from the attorney because I'm going, well, I've got all my text messages. I never delete them. Just like if we send anything, we have everything. I've got 7 years worth of emails because then I got to go clean it out. So I got enough room. So you got to have at least 7 years. Let's see. Agent assuming that all purchase agreements are the same. See, like, you know, I'm here with a gang in Ann Arbor, but many of you are in the metropolitan Detroit area. And many of those agreements are based off of a GMAR purchase agreement. And you think, oh, well, this is a GMAR agreement. Is it? Because companies will take that and create their own. And all of a sudden you have a change in a word, one word. They put one little phrase in and all of a sudden you got something you didn't know you had. And it's going to cost you and your seller, your buyer, because you did not know that. Assuming that all the mutual releases are the same. Now there's a reason, and you need to read them, but there's a reason that when we're holding the earnest money deposit, that we want the listing broker's signature on it. They may have claim to that. So we want their signature on it. And there's a lot of other things that could go on, but when you get a mutual release, read it in the finest detail to make sure that it is what you think it is. Multiple client situations, understand the agency and then use all the correct forms, do everything correctly. We know when we go to a dual, when we go to a dual agency situation that we need to redisclose. That's better. There's nothing wrong with dual agency or anything else as long as we do it the right way. If you're not 100%, you go see your branch manager. Verify and confirm everything with both clients. You got both sides, verify and confirm. Everything needs to be in writing. We know that anyway, but don't assume anything. And then avoid asking one client to communicate with the other. It gets nasty. I hate to do it even after closing, but I'll allow them to exchange numbers. Makes it easier on me, but after closing, prior to closing. Yeah, and here's the whole thing.
I know.
Settle down, settle down. Somebody just lived what we were talking about. Guys, it can bite you in the butt because they do. They start talking and all of a sudden they come up with these verbal agreements and you're not a part of it. By the way, verbal agreements, it's no longer a real estate transaction. Hmm. Yeah, Matt, go ahead.
Situation, one of the pressured me, they said, hey, this is the deadline. He had his client call my.
I had that. Wow.
Multiple offer situation Matt had, and one of the agents had a buyer who knew the seller. He had his buyer call the seller directly. That's getting slimy. Now, I was involved in a multiple offer situation where we had already made the offer. We got very aggressive. We said, we'll give you, we were like $25,000 over the asking price, but we need a response tonight. We did that so that they didn't hold an open house the next day, or we didn't find ourselves in a multiple offer situation. But the neighbor was an agent who contacted and talked to the neighbor directly about the real estate transaction. We ended up losing. Well, we were right on too. They were going to say yes. Till that happened. Let's see. Risk reduction practices, avoiding liability. Don't make guarantees. Don't make any guarantees. You can't do it. Use appropriate language in emails with clients. Before you push the send, read what you put down there. Avoid being too optimistic. I always refer to myself as a realistic optimist. The glass is half full and it's going to get fuller, but I'm also realistic as to what the circumstances are. Never make a guarantee, be too optimistic. Anything can happen. You know, the biggest time to not guarantee, like, oh man, look, the market is hot. Right? We're multiple offers. Well, we'll have it. Matter of fact, we should have an offer in the first 7 days. Guys, it's a time of year. We have the natural seasonality slowdown that's going to hit. You're seeing more withdrawals and price reductions now, and it will continue through September anyway, if not into October. Why? Because as agents, we're overpricing, or we can't get the seller to understand the seller's overpricing, and they're still expecting this when this is the reality. The market's not going to catch up. Now look, great houses, price right where the house is in balance with the price, boom. But I still don't guarantee it. Okay? Fences. Oh yeah, no, this is one where you can get it. See, that house over there has got a fence. You couldn't see the pool, which is the reason they got a fence. They have to read these documents themselves, the swimming pools, accessory structures. Look, they've got one. Well, they probably had to get a variance. Or who knows what the reason is, but we can't guarantee just because we looked. They need to get, as much as we would love to provide the higher level of service and get all of the answers for them, there are just things that we should not do. We should guide them and direct them. But I don't want to call the township for something and then go, yeah, Tony, you're good to go. I talked to. Well, I'd probably document that I talked to Elizabeth at the township hall on Tuesday, the 22nd at 12:44. I would document that somewhere, that that's where I was and this is the conversation. Is that going to keep him from suing me? No. Encroachment issues. Avoid opinions on repairs after an inspection. This is tough because you get some inspectors where they got to earn their money and satisfy their ego. Yeah, we've been around. Just avoid your opinions on repairs. Get credible individuals in on it. Who should handle the repairs? We already kind of addressed that. That's best. Let the buyer do it. Then they're in complete control. So negotiate in such a way that the buyer's in control and I don't have to deal with anything after closing. Get everything done before closing. We'll talk more about that. Don't repeat representations made by the seller or a listing agent. Now, at best, you do this. You know, and I called and I talked to Tony and here's what he told me. But I believe that you should get that verified yourself. So if I give any additional information, I'm going to say, but you should have this verified yourself. Listing agents try to do it by the BotVi, is that what it is? Buyer's agent verify all information. Yeah, yeah. Often it should be simple as the buyer. But all the information, the MLS, you just gave the representation from a listing agent. Because where did the listing agent get it from? Well, they got it from the previous listing, which was an expired listing. I hope I'm just these little punches are, I'm getting you somewhere in these. Let's see. Oh, qualify all your statements. There's a lot have been with me before. I'm not an attorney. Here's what I know. I would suggest that you, if this is very important, you should. I'm not a CPA, my understanding is, but I would recommend you still reach out to a CPA. Okay, qualify your statement. Which brings up, do I need to tell them 2 or more suggestions? Can't hurt, it's great risk reduction. Problem is, if you can tell them 2 or 3 people, but you know which one they should call. Because listen, I've got a preferred lender. I would prefer that they use my lender. I've never had an issue. I've never had a deal fall through working with her. But complete all sections of the contract. Understand all the terms of the purchase agreement. Understand all terms. Every paragraph. You should look through and read and make sure. And it's tough, guys, I know. See that light? Let's go there. I would like somebody else to tell me everything else. It's difficult for me to review everything with great detail. Listing agent must review. Notice I've now got it in capital letters. All the terms of every purchase agreement received. Because they're not all the same. I know if I got my Lansing crew on here, you have a little bit of an exception. Lansing, literally many of the offices, and probably most of the offices in Lansing use a Lansing Board of Realtors purchase agreement. Look, that's nice. It's a lot more to where you fully understand it because it's what everybody's using. But most of us, they're not the same. Next bullet, fill in the blanks. If it's a line, if it's dashes, if it's not applicable, if it's N/A, if it's 000, get something in every blank. Mutual releases with compensation or protection clauses. Well, make sure you read them and understand what they say. That's a basis of what I can say. Protection clauses could be on there. Again, it's the reason we want, when we're holding an EMD, we want the listing broker signature. Like I'm here in Ann Arbor, Matt is my manager. He needs to sign that in that case, not the agent of the listing broker. Okay. Let's see. Referring your clients to the expert. Client time. Oh, guys, this is oddly enough, but I don't think you've ever really run into it. Thankfully, I haven't either. Buyers will try to avoid hiring an expert. They want to rely on your expertise. I mean, they look at me and they go, Darwin, you've been in the business 38 years. You've seen a lot of this. What do you think? And I have to, because listen, I know the answer. Literally in 38 years, I've run into a lot of stuff. I could give them the answer, but I have to resist. It can and will be used against you if you do it wrong, or if they run into a problem later. Basement cracks, evidence of water, tree roots, open electrical, you name it. All of that goes into whom do you recommend? Make sure you've got at least one solid. If you're going to practice risk reduction, yes, you're going to have 2 or 3 that you could refer to them. Everybody's been asked this unless you've just gotten into business. How should I take title? Guys, I can tell you most of you don't even know what they mean by that question, and they don't either. Because you're going, well, you know, you get title insurance. And guess what? The title company shouldn't be doing it unless if there's an attorney on staff. You see, we're practicing law. Because before I can recommend anything, I need to know what the different ways of taking title are. And then, by the way, I can't tell you. Well, here's what this one says. Well, how should I do it? I can't tell you. I can't make recommendations. That's practicing law. Okay?
Well, the two title companies that I use have attorneys in-house that they refer.
Yeah.
To.
You will see most of the time, and once they know it's a married couple, I will tell you that there's an assumption that they're taking it as tenants by the entirety. And to take title that way, they have to be married. But that means that there is a particular way that if there's a passing of one or the other, what happens to who gets the house and what do they have to do? Here's another one. Repairs not performed on property, or because everybody knows the purchase agreement says the property would be transferred broom clean and free of all personal property. Guys, if you got a seller, they're not likely to be doing anybody a favor by leaving a couch or paint. That's the best one. Well, I've got all the paint from the 28 years that I've lived here. Buyers don't want it. So if they are wanting to leave something, ask the buyers if they want it. Okay? Don't assume. But if it's not in the condition, you do your walkthrough before closing, and it's not in the condition that it is supposed to be, do not close. Don't close. And if you can avoid any post-closing agreement, avoid it. Don't close.
What do you
You're gonna have
recommend
problems.
when there's occupancy after
Just check and see if
closing?
you're okay with that one. You haven't had that one yet. Good. Because when Jason brought this up, I'm going, I don't get it. I've never run into that. What are you talking about? He gave enough of I went, oh, but I've had to handle it for everybody else. Don't close.
Until they got the house.
Had both sides is what she was saying, that she represented both buyer seller, had both sides of the transaction anyway. And it wasn't the condition it was supposed to be. So we didn't close until it was all cleaned up. That it was being transferred as to the terms of the purchase agreement. So when we review, when as a manager, we review all the paperwork, we're reviewing that to make sure that we're closing in regard to how it is on the purchase agreement. Are we closing in the terms or in accordance to the terms of the purchase agreement? Now, remember, who knows the property and the transaction better than the manager? You guys do. So make sure that you're getting that taken care of. John, with respect to taking title, I typically provide all the options available in Michigan with considerations for each option, but without recommendation. I would resist doing that, John. Yeah, I would hold off because you're providing information that they're going to rely on to be able to make a decision. So I would, typically, I would never do it with everybody. And I would probably next to never do it with someone. I'm going to give them a little bit of rundown for what I know and what they should talk to an attorney about. Because with what you're telling me, you might want to consider taking it this way, but you should talk to an attorney about. That's the way I'm going to handle that one. What do you recommend for occupancy after closing? Final walkthrough prior to closing, but not possession. Wow. Guys, it's one of the things that we have regarding post-closing occupancy. We're in trouble if there is any trouble. I can tell you in my 38 years, I've ran into it once because, matter of fact, it was my neighbor. And I'm outside doing work when the seller's mother rented a big 28 or 38 foot no, not a U-Haul. It was a Ryder truck. So it was like, Lord knows why she was driving it. And I'm sitting here watching her back up, back up. I'm going, oh, please stop. Back up, right into one side of the garage. Post-closing occupancy. What do you got to do? Handle it. Mhm.
Because the buyer comes in with insurance, the seller usually keeps the insurance on the property. Which insurance company would be responsible to pay for the damages? Because it is technically usually double covered. I've always wondered what happens in that situation if something were to happen with occupancy.
This one was seller's insurance covered it. Because it was the sellers who possessed the property still at that time period. It was the sellers who damaged the property.
Yeah.
So they covered it.
Would be more the buyer's insurance or would it be
Well, if the
seller's insurance?
buyers damaged it, the buyers are responsible for all costs up until. But if the buyers damaged it, they probably had possession.
Well, you just never know.
Right,
I mean.
right.
Right now.
Yeah. One of the things that people do talk about is having a post-closing damage, whatever they call it. I'm going to say my opinion toward it still hasn't changed. I'm not a fan of it because I actually had one of my agents who was a fan of it, drafted something up that was good, and she ran into the same thing it would have been if we hadn't had post-closing damage, occupancy addendum, whatever you want to call it. She still had to fight, and in the end, she couldn't do anything about it. It was up to the buyers and sellers. The only difference, the only real difference was the money was in escrow. Now, if you're a seller, you want to sign that? Say no. Why would I want to tie up my money and put it for this person to have to say yes to release it to me? They didn't like, and they said, well, that's a hole in the wall. That hole wasn't there. Yeah, I'm not a fan of it. I think it creates a lot of additional hassle for you as an agent, for us as a company, and in the end, they're still going to end up in court, and the only thing it was is there's money in an escrow account waiting for a judge to be able to say who gets it.
As agents to get the sellers to take action.
Yeah. Yeah, most of the time, here. I can't think of a time ever in 38 years doing all that I've done that I've heard a seller being a bonehead when they damage the property knowingly. Yeah. I'm not saying it won't happen. I think it will happen, but for the few that it will happen, I don't know that it's worth all of those that won't. And there's a lot of other stuff that can go into that also. So I think there is a clause for post. Okay. Not requiring anything to be done past. Yeah. So you guys got it there. All right. Do your homework. Secure your letters of authority for a personal representative. If you don't know what that means, find out. Is there a trust? You are highly, highly likely to need a certificate of trust. I can tell you that, look, you can do everything in your power, and I've got one that we're closing tomorrow, that we've done everything. And title company didn't hear that we told them before that they are living in an assisted living. And they went, oh, well, wait a minute, that creates a problem. Are they of basic sound mind and body? And it was, they haven't asked us for a certificate for it yet. But then it's like, well, but we've got 3 other individuals, which is their kids. What happens if one's not? Well, say when we need a statement from the doctor that says they're not, and then one of them could. And literally, we had all of this set, and thankfully everything's still good, and we're going to be able to have both of the sellers be able to sign. But we did everything that we could. But I'll tell you, the other part is it was an old trust signed in '91. Now, if anybody's seen a trust, how big is it? Right? Normally, you're going to see it in a 3-inch binder, sometimes 4. This was 1 page, 1 single page. So they had to sign an affidavit of trust to say that it was still in existence. And look, guys, order pre-title. The title companies are fine with this. You take the listing, it's going to sell. In this case, we knew we were going to have the listing and it's our title company. We said, would you guys do the title search on this early? Because we didn't know how they were holding title, meaning was it the trust still? Did they take it out of the trust? Is it order pre-title so that, you know, this sounds really weird. And if you've been in the business and you get a lot of referral business or you've been in repeat business, you know the people. Most of the time we know the people that we're going to. But do you know the person who's signing that document is the person that owns the property and has legal authority to be able to sign on their behalf? If you don't, you might want to get driver's license. We got to know that they are the legal entity that can sign. Elderly client considerations, be careful of clients in assisted living. I just gave you the example of that. Durable power of attorney means that they can sign on behalf of that individual for anything, including real estate. How long is a durable power of attorney good for? Upon death, it's gone. It no longer exists. So any power of attorney dies with the individual who gave the power of attorney. And of course, a reminder, they must be a sound mind and body to sign legal documents. You could have a deal fall apart at the closing table if somebody starts going, it would be all it would take. Or what's today's date? I'm sorry, what's today's date again? What's the date? What are we doing? Why am I signing this? All of those, you could have a closer go, I can't continue with this. It can fall apart that easily. Yeah, obviously I got to run discrimination. Don't let it happen. Don't do it. It's interesting how simple it can be that people will think they're not discriminating. They are. Walk away from those who are or will discriminate. And if you get surprised after a contract, terminate the contract. Get with your branch manager ASAP, terminate the contract. We don't want to be drug in. We want to be able to say as soon as we were made aware of the discrimination that we terminated the contract. You're going to document that this contract was terminated because. All right. I'm going to make it that simple because it's that simple. And we're almost set here, guys, and I'll wrap this up. Wire fund transfer. I hope you all understand why we do the wire fraud disclosure. It's just got to be done. Buyer, seller, it doesn't matter. You think, well, yeah, but they're not going to have a wire transfer. They might. They might be receiving it. They don't want to give the wrong information. They want to do everything right. Yeah, what we want to do is to have them sign the disclosure and get out of the way. But when I sign the disclosure, I say, no one will ever call you asking for your account information and tell you where it needs to be sent. Almost always, it's online. The most I get involved with is I would go, Elizabeth, just call the title company. Ask for this person at this number, at this extension, and confirm that you've got the right information. Okay? And that's almost always in title company's package with instructions on how to be able to do the wire. But even that makes me nervous because that could have been intercepted. If there's a wire, just make sure that everything is all set. Don't negotiate through text messaging. This one was a surprise to me, but it's what Jason gave. It's just not as reliable for you. It's not going to stand up as well in a court of law. So avoid text messages and use email. Obviously, get it in writing. This is a bit of a surprise, but as I put it, what is a, quote, mortgage commitment condition only upon marketable title and satisfactory survey? What does that mean? Anybody out there got any idea? Just, you know, funny faces work tells me that, guys, it's up for interpretation. And most purchase agreements are written in this way. And I have had, thankfully it was in negotiation, tried to get an understanding of what it was because this guy wanted it in 14 days. I said, I'm not gonna be able to give you a commitment in 14 days. Nobody can do that. And this was back in days of 30 days to 6 weeks to be able to get a commitment. Like clear to close, which is what we're always looking for. But I gotta tell you, I don't know how to interpret that, but this is the way that most of them are written. Jason's suggestion, the attorney, was you might want to coordinate this with a closing. Otherwise, when will I have the clear to close? If I put it for July 7th, that means I'm planning on getting clear to close on June 30th. Make sense? I wouldn't make that 15 to 21 days unless if you're closing in 28 days. Because it's open for interpretation, and our Plymouth office actually had a seller who I'm sure the situation was, they got another offer with better terms. And they called to go, yeah, your deal's dead. We're going to go with this other offer. They didn't put it that way, but that was their thought. Their reasoning, you haven't provided your commitment. By the way, can I get a conditional commitment within 7 days? But is that what this is going to interpret to? And then tenant occupied properties. Just if you have that, I'm going to suggest that you get with the manager to be able to make sure that you got everything covered, protect your investor, most likely, when it's tenant occupied. That's the best way to be able to do it. So again, I'm thanking Jason Sakis for providing what he's done and his perspective with everything. And I thank you, and you all know what to do. Go talk to people.